everybody, Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today, we're going to talk about not making your estate plan too restrictive. Before we get there, however, if you have any estate planning or probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, this question has been mingling in my mind a little bit recently because there have been clients and prospective clients asking with regard to certain assets and how they can set them up under their estate plan for the future generations. And I guess trying to figure out a way in which they can somewhat control what happens afterward. First, once you're gone, you don't want to have that control. You can't really have that control, but you don't want to have that control, and you don't want to designate anything too specific. For instance, if right now investments in a particular type of bond is a fabulous idea and it's wise to do so, that doesn't mean that's going to be the same 30 years from now. Same with any kind of investments. Same with real property. If you specify that someone in particular should receive the house, which again can be a fairly common request, you have to think through whether or not they'll have the funds to manage that property and either allocate for that or not make it so restrictive. At the end of the day, your estate plan should be extremely flexible and allow for changes in those initial wishes because life does change. And the variables that your family will be dealing with after you're gone may be very different from the day you set up your plan. And so we have to think ahead a little as we're thinking through the assets and our beneficiaries and how we would like to see them distributed to them at some later point in time. Being a little bit more flexible in your mind and of course in the estate plan is very valuable to them. And in that way, as long as the documents have some flexibility built in, there will be no need to appeal to a court to make adjustments to, say, an inappropriate, investment design that was mandated within the estate plan. Nowadays, I think most places do allow for sort of the prudent investor standard and allow a trustee or a fiduciary of any kind to make adjustments accordingly, but you want to give them as much flexibility as they can. And as a reminder, if you have any estate planning or probate questions, you can reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for listening. If you found this information useful or think someone else may, please share, like, and subscribe where appropriate so nobody misses out. Again, I'm Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Take care.